Some of that is spilling over towards Wayaki Way, but nothing too crazy. You can handle this. And then as you come in on Uhuru Highway, if you're coming in from Mombasa Road out towards Capital Centre, you get to the Nyayo Stadium roundabout. It's going to slow down just a tad, and your junctions of Lusaka, and then getting to Bunyala, and then Haile Selassie. That's busy. Jago Road towards Landis also doing the thing this morning. Kamkunji at the roundabout is pretty busy as well. Traffic hour things, and we'll get out of it in a bit. Let us know what might be looking a bit sticky, and we'll talk on Spice FM KE on X.
Mature, intelligent talk every morning. Spice up yourself. Mornings done right. 94.4 Spice FM, Nairobi.
Coming in at 26 minutes to 9 a.m., having a conversation with the chairperson of the Land Acquisition Tribunal, new one. Dr. Nabil Orina is with us this morning on a Justice Thursday conversation. I'm looking at access to justice, and we have heard the Chief Justice numerous occasions talking about we need to simplify access to justice. Number two, we need to then make it widely accessible. So those two things, simplify it and let everybody have access. Now, when we remove this component of the government acquiring land from you as an individual from the Environment and Land Court, then it occurs to me that perhaps it is a recurrent issue and that there are several issues around this particular component. For it to be removed and a tribunal set out solely for this purpose, that has happened. Does that mean that there are very many cases around this particular issue whereby individuals would have an issue with government and how they acquired their land?
It is the case that even the Constitution, by separating the High Court from other specialized courts, that is the Environment and Land Court and the Employment and Labor Relations Court, was also trying to ensure that each court would deal with the specialized matters and ensure that indeed there is a quicker dispensation of justice. But when it comes to tribunals and the Land Acquisition Tribunal, and it contributes to access to justice in a manner that this is a judicial organ, but not a very formal way of coming to court. More of an administrative organ to deal with questions that are more administrative in nature before you can end up in court. Because then if you are dissatisfied with the decision of the tribunal, you have a right to go to the Environment and Land Court on appeal, but only on matters of law. So tribunals contribute to access to justice because of how they operate in terms of regulating their own procedure, not strictly following the set rules of procedure and evidence, strict timelines, and this is also in regard to I believe which has been discussed in this show, the Small Claims Court.
Yes.
Which then was necessitated by the fact that there are some disputes which are of a lesser nature, but they are stuck up in the court system. So instead of having questions about compensation for land that has been compulsorily acquired stuck up in the court system for years, then you put them in a tribunal where someone knows that if I'm dissatisfied, I can approach this tribunal and I can have a determination within 60 days. So that enhances access to justice. And because land is a big component of a driver of the economy, then people want to know that issues around this land that is being taken away from them are quickly resolved. And also because sometimes land, when government wants to acquire your land, it could have been the only property that you had, but government has said that in their plans they want to build this infrastructure which will serve the community, and they've taken the only piece of land that you had. You cannot wait for 2 years before you resolve a dispute in regard to how much you should have been paid.
I think my question would be, is there plans to have an awareness campaign with people in the community, in the grassroots, and which sort of stakeholders would you be looking to collaborate with? Because even thinking about the narrative of basically taking government to court is not a easy thing, and you know how it is, especially in rural areas. People tend to be afraid of going against and just saying, whatever we receive, equal to, we have that mentality of appreciate what you've gotten, at least you're alive, because there's that fear, that sense of fear of authority. So I'm curious to know if there's a plan to educate the public that this is accessible and it's also affordable and you're also reachable.
Yes, indeed, the whole aim would be to reach out to as many stakeholders as possible, and we are starting. This is our first official, reaching out and trying to do sensitization about the tribunal. But then also, what we will do as a tribunal is to simplify the procedure of approaching. If you have a claim and you have an appeal from this compulsory acquisition, so that then it's as accessible as possible, not just because you can come to the tribunal and quickly get your issues resolved, but then you do not have to go through complicated ways of filing pleadings, but you can have a simple kind of form to fill in your grievance, and you get help to get it uploaded online, and then we can have that kind of resolved. But I agree with you as well that indeed there are certain communities. Already we have noted a number of areas where most of these claims are coming from, or where there have been a lot of complaints about the process of acquiring, compulsory acquisition, and the compensation. So we have plans of going closer to the people and trying to inform them. We are also involving the Law Society of Kenya, because as much as we want everybody to be able to approach this court, without necessarily having to find a lawyer. Lawyers are also a key component of justice and access to justice. So we're reaching out to them. We're talking to them through the CPDs, that is continuing professional development, just to also sensitize everyone around the work of this tribunal and how to access it, and what to expect from it.
So how do you access it, Daktari? Because here we are saying that there could be, and it could be in the probably looking at a lot of these cases coming from rural Kenya.
Yes.
Right? Just because of how geographically things are set up and where folks own land. Okay? So if something happens and you find yourself in a situation where actually, it's the tribunal that would be able to figure this out for me. How do we start? Who do you pick up the phone call? Do you visit a local office? How does the process play out? What do you do?
Well, of course, the access point is through the judiciary e-filing system.
Okay.
But we accept that, of course, that is not something that is known to everyone. So in our notices that we're putting out, we have our court administrators and their personal numbers and their personal emails, for persons who have challenges to, in terms of the procedure to file some of these claims, to call so that they can get the support that is required. You can be, guided through, how you can get to file online, and, your documents are uploaded, because the online filing system is it's actually a simple one, but it might not be simple to everyone. So by offering this kind of support, then it ensures that whoever is having a challenge uploading or knowing how to file or what kind of document to file, then they can easily reach out to our court support staff to enable them to do that.
And you need to pay to file?
There is a minimum filing fees, which I think is about 1,000 pop, which is in the system, because the system also requires that you have to pay to upload certain documents.
I want to come off a question that Nerima asked, because the thought of taking government to court is foreboding at best. And you say, you want to take my land, and you've already established that we are not talking about whether you can or cannot. So long as a particular threshold has been met, the government can actually come and tell you, look, we're taking this, we're going to pay you for it, but we're taking it. So we're saying that the tribunal is kind of like a fact checker.
Yeah.
To come and say, okay, did we do this? If you did, actually, then government can have your land and they're paying you for it. So if you have an issue, we can come and we can go through those facts and we can check. So it is not to dispute whether the government can actually take this land from you. What you're disputing or what you're adjudicating over is the technicality as to whether they went through due process, whether they took up the responsibility to do things right. That's essentially what we're saying here, not questioning whether they can take it or not. Am I right?
Yeah, that's correct. But you can actually question whether they can take it or not. That is the first thing you can question.
Okay.
You can question whether the purpose for which the government wants to acquire land is a public purpose.
Okay.
Yeah, because and that is a question that can be determined. Can come before the tribunal, and the tribunal can make a determination on whether this was a public purpose. And before even the land, the government takes your land, once this request for compulsory acquisition of land comes to the National Land Commission, the National Land Commission is required to put out a notice through Gazette to state that government intends to acquire your property. The following are the identified owners of the property. This is the particular property that is required to be compulsorily acquired. And there's a requirement that that notice has to be served on each and every person who's interested. So that is the person who owns the property, the person who's resident on the property, and then after that, there is a public inquiry where the National Land Commission will come to you, sit down with you, listen to your representations about your property, listen to representations about how much you think it's worth to be paid, and then make a decision. So after that decision has been made, after the National Land Commission has made a decision that yes, indeed, because already they have certified that this is the acquisition is for a public use, then they make a decision on how much you should be paid. Then that is when you can approach the court and say, there is a step that was skipped, or the inquiry about how much I should be paid was not done properly, and they left out a number of things. The improvements are done on the property. If you had some structure, they undervalued the structure. How long you've stayed on the property, whether you are resident on the property, whether there are other people resident on the property. So those are the small details that have to be taken into consideration in order for a just decision to be reached, because the law requires that there has to be just compensation. And the just compensation from the jurisprudence available is that whatever you're paid has to follow the principle of equivalence.
Okay.
Put you as close as possible to the situation you were in before the compulsory acquisition occurred. So, and also you also have to see the mandate of the tribunal as striking a balance to ensure that the person who has been deprived of property is justly compensated, but also public funds are prudently used so that there is no opportunity, as was stated in one of the cases called Patrick Musimba, for looting, for instance, because there could be a ploy to acquire a property which its value to you, would have been 500,000, and someone wants to pay you 5 million.
And who are you to refuse?
Yes. But then, so the tribunal has a mandate to either vary, quash the whole process, or uphold the whole process by the National Land Commission.
Would the tribunal get involved in cases, and this is the question coming from, that, sometimes you're traveling about and you see that private companies have installations on your land.
Absolutely.
There's something, they maybe pay you something every month kind of thing, or per year. Does the tribunal get involved in that, and at what level?
The tribunal's mandate also extends to what I refer to as way leaves and easements. So what they're talking about...
Excuse me. Yes, explain those two things.
Yes. I'll start with the first one that they're talking about, a way leave.
Yeah.
So if, an installation, a telecom company wants to install something on your property, let's say a telecom mast, you have a right to be compensated for that installation. And that is what is referred to as a way leave.
Okay.
An easement, on the other hand...
Spell that one is? I-S?
Easement.
I-S-M-I-N-T.
E-A-S-E-M-E-N-T.
Easement.
Is this English?
Yes.
Easement.
And on the other hand, an easement is a non-possessory right, where, for instance, you have a right to views or to light. And someone comes up and builds puts up something that completely
Oh, really?
blocks you from
Natural light.
Or it could also be that I think this is a lot in the village where there is a natural water spring, and we could pass through someone's land to go and collect the water.
Yes.
But if someone one day says that you can no longer pass through my land, but then that is the only way to access the natural water spring, which supplies the village with water.
Yes.
You can come to the tribunal.
Who?
The person
the owner of the land.
No, not the owner of the land.
The person who wants to go and get the water can go to the tribunal and say, we've been walking, but sorry, Daktari, you're walking through somebody's private property to approach this public resource.
Yes.
Isn't it? Public natural resource.
Yes.
So who would go to the tribunal? Go to the tribunal and say, force this person to allow us, it's their private property, to allow us access to this public resource? You
are not forcing the person to allow you. This is something that you've been doing since, for generations and generations. So you've acquired an unpossessory right to this property. You don't own that property. You don't own that land, that path that you pass through. It's not public road, but it is a right that has crystallized, and you cannot just take it away. So, and that is the same thing with someone who blocks you from light completely. You don't have. Everybody has the right to do whatever they want within their property. But if whatever the person does in their property completely changes, either the kind of views that you had bought your property for, or light completely, that you can't access light and all that, then you can challenge that in court and in the tribunal, and the tribunal will make a determination to say whether there is an easement.
I think I have a case. Let me see where I live. Someone, it's I don't know what you call it. When it rains, I live at the bottom of like a hill. So someone has constructed a house and fenced it, and the water used to naturally flow through the bottom of the hill into a seasonal river.
Yeah.
So now, because he has put a wall, it has caused where I live to flood. But he says, this is my property, and I've put a wall. But the neighbors are flooding, and we're afraid of El Nino. Actually, right now as we speak, there's a lot of running all over the neighborhood, and people are trying to... I don't know what they are doing.
So if you remove this wall, that problem wouldn't be there.
The water would flow.
It would not be there. So
is it possible to build a wall and leave a passage for the water to pass by?
It is possible, and that's what we're pushing for. But he seems very stubborn about us breaking his wall.
Well, I'll not make any further comments. Otherwise, I will have to recuse myself if you come before me. But then you have a general idea about easements, and indeed...
It's the sort of case that one could bring.
Okay, so this kind of makes sense. So then this is what my initial question, that there could be then thousands of cases Dr. Orina, that would come before the tribunal? Because people have been dealing with things. A road is constructed. There used to be hawkers on the side of the road whose now sheds were removed as a result of that. And they, according to what you're saying, what did you call it? A non-possessory right to that place, because they've been buying and selling, creating a livelihood on that road. You've decided come and construct road, and you've said now this area where you've been will be beautification. You no longer have access to. Is this one of the things?
Well, it's slightly different, because it goes into planning and city and the right of county governments to do this. And they have other mechanisms for grievance settlement, I think, through within the mechanisms of the county. And then after that, if you're still dissatisfied, you could go somewhere else. But there are, similar situations where the tribunal could have jurisdiction.
So are there prerequisites that you look at, like a pre-list that you say, look, these are the things that we would say meet the threshold to come to the tribunal? Because I can envisage a situation whereby everybody and their uncle is going to come with cases whereby it has something to do with what we were used to doing before and what we cannot do anymore on this particular land. Would you sieve through and say, if it meets threshold 1, 2, 3, 4, 5, 6, then these will be heard before the tribunal? How do you know what cases to take and what to not? Because I'm sure, like Nerima, there are many people who say, this tribunal, we're waiting for you now. You are here, we're bringing our case.
Well, the cases will be filed before tribunal, and the same way they are filed before court. And sometimes the tribunal or the court would look at the case and say, well, this looks like there's a problem here, but unfortunately, it's not something that we can adjudicate upon. And the judiciary, through the Chief Justice's social transformation through access to justice, this access to justice, it also follows what is referred to as a multi-door policy, where, for instance, if you file something wrong before the tribunal, we can look at it, and because the tribunal has to enhance access to justice, then we can tell you that what you filed before us probably belongs to another tribunal. That is, not shutting the door on you, but just
referring you,
telling you that you should file this before the National Environment Tribunal. If it's a question of the environment and resources in regard to that. So that is also a way to foster access to justice, not necessarily shutting the door on someone, but there's a possibility that you will get cases before you that are not your business, and you just have to either advise the parties that you can file this complaint in a different jurisdiction, or we do not have, when we look at the law, because when a case comes before you, you have to look at the law and determine whether you have jurisdiction. And jurisdiction is found in the law. Does the Land Act or any other law give you powers to adjudicate over a question like this? For instance, in regard to an easement, would this be an easement? Would the definition of an easement also cover, certain other issues that, are not necessarily thought to be, outrightly to be an easement? So you have to, make a determination at that stage. And the first thing to do is determine whether you have jurisdiction. Yes.
This is one of the most interesting conversations I've had regarding the law. And why I'm saying it's interesting is because it sheds light in an area that has hitherto been very grey. Like the cases we read about and we talk about, say for instance, people were supposed to be compensated when the SGR was constructed. And you hear that some were not compensated. There was this amount. National Land Commission had this to say. A lot of fluff and a lot of dust about it. I am waiting to see how some of these things will be resolved.
Absolutely.
It'll make for interesting reading and hearing. Yes.
Yeah. We look forward to make determinations that will, restore confidence in, problem resolving mechanisms within the judiciary.
As an almost final one, will you be looking at cases that have some history? Because people might come and say, well, okay, this has been tied up in the courts forever and there's been no adequate adjudication over it, and now here's this tribunal. Can you bring a case that has been wrapped up in legalese and the law forever and say, well, now that the tribunal is here, this is clearly a cut and dry case for the tribunal. What kind of statutory limitations will you be looking at when it comes to cases here?
Of course, there is a requirement that you should appeal to the tribunal, 30 days after a decision has been made. However, and even this would happen in any other court, where certain circumstances, extenuating circumstances, that a party comes to court and says, I seek leave to file out of this period because, we have been embroiled in a dispute over even ownership of the property that was taken. Because before you can even determine whether the compensation was sufficient, parties could be, disputing on who owns this property.
In the first place.
And that is not within our mandate. That they have to go to another court. So they would have been stuck in the Environment and Land Court for years trying to determine who was the right party to be compensated. And then when eventually the Environment and Land Court says you are the right party to be compensated, it is 5 years down the line. You cannot shut the door.
You can't shut the door.
Yeah.
It'll be very interesting to see how this plays out. We'd love you to, give us feedback on how this happens. And it looks to me like that thing when you open the gates and there will be hundreds of cases that